Welcome to the 19th episode of the 39A podcast. This is Shivani Misra from Project 39A, a criminal justice initiative based out of the National Law University in Delhi. The Supreme Court recently, in Vijay Madan Lal Chaudhary versus Union of India, upheld provisions of the Prevention of Money Laundering Act, or the Pmla. The idea behind enacting the Pmla in 2002 was to uphold India's international commitments in addressing the global issue of money laundering. The Pmla creates special procedures for investigation which are distinct from the Code of Criminal Procedure. Investigations under the Act are carried out by a specialized agency known as the Enforcement Directorate, or the ED. In around 80 petitions, various provisions of the Pmla were challenged as being excessive and violative of constitutional safeguards. Therefore, what was at stake before the court was the balance of individual rights and state power. These needed to be interpreted in the backdrop of long-standing jurisprudence of the Supreme Court on these individual rights. Today, we have Senior Advocate Mr. Aman Lekhi with us to explain the implications of the judgment. Sir, one of the provisions that was under challenge was the very definition of money laundering. Without going into the nuances of the definition, broadly speaking, Section 3 of the Pmla states that whosoever directly or indirectly is involved in any process or activity connected with proceeds of crime and projecting it as untainted property shall be guilty of the offence of money laundering. Sir, could you speak a little as to what the court has stated is the offence of money laundering and what are the key ingredients that constitute this offence?
Well, in any interpretation, the arrangements of words and phrases and the structure of the statement is of material importance. And I feel while construing Section 3, certain relevant aspects have been overlooked to give Section 3 a meaning which is not, strictly speaking, flowing from the terms in which Section 3 is drafted. The focus of the court has been on holding that possession simpliciter can attract the offence of money laundering, to suggest that the projection or claiming the proceeds of crime to be untainted is not a necessary ingredient to complete the offence. I personally feel that this reasoning is flawed. And I have a few reasons for so saying. One, what I feel has not been given adequate importance is the use of two different conjunctions, or and and. Now, one is disjunctive, the other is conjunctive. And because or and have both been consciously used, that means the legislature knew the meaning of what or and is, and deliberately used and, having used or, the meaning that the legislature intended to give and could not be or, firstly.
Sorry to interrupt you here. Could we just maybe read out that portion of the section where the and the or appear, just for the benefit of our listeners?
So the section says, proceeds of crime including its concealment, comma, possession, comma, acquisition or use, and projecting or claiming. Right. So what you will find is there are two ors and an and. Right. Or and are conjunctions. That means the legislature is aware of the rules of grammar, presumed to be aware of the rules of grammar, and the court should defer to the understanding being correct. So when and or is both used, which was not the case in Sanjay Dutt's case, I'll come to that later, on which reliance is placed. You cannot easily give the meaning, the word and the meaning or, because in any case, even where this is warranted, it is only where the meaning is otherwise unintelligible, where you give and a meaning different from a natural meaning, so as to make it consistent with the objective behind Section 3, which is not made out over here. So, as I said, one, and or are both used, and being so used, to say that and should be used in or is inappropriate. Number two, in reaching the conclusion, the court was heavily influenced by conventions. Now, when you are influenced by conventions, the conventions may have a role to play in interpretation, but conventions do not in any way rule the interpretation. They are aids to interpretation. Even the conventions as such recognize that the domestic law will prevail. That is, the understanding of domestic law will actually prevail. And when the wording of a statute is clear, a meaning different from the ordinary meaning cannot be ascribed to it by reliance upon conventions. So the question of conventions warranting it, in my opinion, again, is not in any way warranted here. The court was influenced by Sanjay Dutt's case, which is one of the many cases where the court had used and as or, but the context is very different. Because in that sense, the structure, and I said in the beginning, the structure may warrant a particular meaning, but the meaning which is relevant for one structure may not be necessarily relevant for another structure. And the structure of section 3 of PMLA is different from 5 of Tata, which was being construed in Sanjay Dutt. And to import the reasoning without noticing the difference is, in my opinion, was something which could be avoided, because no one can dispute that or and have been used as and or. But the question was there warrant for that? And I don't think there was warrant, because the meaning which section 3 naturally gives is that the activities which have been mentioned by themselves will not constitute money laundering until there is projecting and claiming, which flows from the natural construction of section 3. Having, in my opinion, not correctly interpreted 3, the job of the court became very simple by saying the explanation is consistent with the substantive provision.
Right. Just to give a little more context here. So this explanation is now added in 2019. So do you think this explanation to some extent contradicts the main part of the section?
Absolutely. An explanation normally elucidates, but an explanation can never alter. And the purpose of explanation is to address an obscurity. And obscurity doesn't necessarily mean an interpretation which may be hostile to the way in which a reader may be wanting that section to be read. Now, mainly because you would want a section to be read in a particular way would not necessarily make you want the meaning unless the section has that meaning. And the problem which has happened over here is the want is substituted by the meaning to give the explanation, to make the explanation mirror the want and not the meaning. Now, what has happened over here is those intending to enforce 3 may be wanting possession simpliciter. But their wanting possession simpliciter to be money laundering will not make it money laundering unless it is coupled with projection. Now, when the statute mandates coupling, which is used the word and, which is the conjunction is used distinct from or, another conjunction, to have an explanation give an artificial meaning to the natural meaning of it defies very purpose of the explanation. And for this reason, the reasoning is simple where the explanation is concerned, because they've interpreted the substantive provision to read and as or. That makes the job of actually construing the explanation rather simple, because then you construed the section in the light of the explanation. When in fact you have to first construe and notice the fact that this is a 2019 amendment. Now, 2019 amendment subject to judicial review. The question is the explanation valid? You cannot assume that what is styled as an explanation is in fact an explanation. Because while being styled as an explanation, it may not be an explanation because it is contrary to substantive terms. So this had to be addressed first, whether it's an explanation at all, rather than to be addressed later by reading 3 to mean to read and as or. In my opinion, the way 3 stands, without the projection or claiming of money laundering cannot be made out. And to the extent the explanation says that the projection claiming is also disjunctive, is doing violence with 3.
Right. Thank you so much, sir. Sir, just one small follow-up question on this. Now, when we say that right now as it stands, maybe it'll be construed that possession is enough, would this take away from the intention element that the crime should have, that the offense of money laundering should have?
You see, intention has to be read into it. Again, possession has to be for the purposes of the objective of the act. And so you cannot, the first principle is unless the expression so warrant, intent is implicit. actus non facitrium nisi mensit tria. That is the principle which is usually applied in this case. So it's not my problem is not that, because that will yet be my problem. Is a more troubling one, which troubles me more, is the use of the word policy. You see now I think there has to be a bit of restraint in the way in which important legal questions are in fact articulated. To give a broad power by relying upon policy to interpret penal provisions expansively will, in my opinion, violate substantive due process, because it will inject into the interpretive process things which will fall foul of Article 21. There are certain principles which are normally applicable to interpretation of penal statutes. One, when it is settled that if the meaning is clear, then policy is relevant. Two, the question of policy, or which should not be used policy, should be objective, will become relevant when it is open to a broad and a liberal construction. And it is not, there is no indication as to which of the two, in which again the policy of law would be to give it a narrow construction. Three, there may be ambiguity, but there may be indication that there has to be a broader construction. That means indication again in the statute, nothing to do with policy. Every time you're looking at the objective, this policy and my policy doesn't come. Policy is a different issue. Like you make something wrong. To make money laundering an offense is a question of policy. But what constitutes money laundering is not a policy. What constitutes money laundering is goes to statute. So to say it's a question of policy is again wrong, because it offends principles that are relevant to interpretation. So one, as you very correctly pointed out, I do not think that intention is relevant. I think intention has to be in any case inferred and read into this particular provision. And two, to use policy for the purposes of overbreadth will fall foul of many known principles of statutory construction relating to penal statutes.
Right. Thank you, sir. So, sir, when we're on this policy question, can now any offence be added to the schedule as a predicate offence? So, as we know, money laundering is a unique offence defined under the Prevention of Money Laundering Act, and there is a schedule which lays down predicate offences. So, does this overbreadth also extend to the offences which may be added to the schedule now, or do you think there should be a gravity threshold, considering that so much importance has been placed in the judgment on how severe this offence of money laundering is and how much of a menace it is? Should there be a proportionality in deciding what offences meet the threshold of being a predicate offence for money laundering?
Well, that's not an easy. It's interesting question, not an easy one to answer, because it's not open to very easy speculation. Depends upon the choice. Actually, the question is, if you look at the scheme of the Act, there has to be a scheduled offence, there has to be proceeds of crime, and there has to be money laundering. Now, it is for the government to decide as to what is the nature of the activity which is generating proceeds of crime as to warrant Section 3, that is the offence of money laundering, to come into play. The check is not what should be in the schedule. The check has to be what is to be read as money laundering. And my problem today is the way in which the definition section has been read. Because even if you add to or delete from the schedule any offence, if money laundering itself is construed more expansively than the limits within 3 is drafted, then the schedule is irrelevant. Because through 3, that is the offence of money laundering, you will make offences not within the statute offences. And that is what I think should be a primary concern. And the ease with which you construe definition clauses to rope in acts, strictly speaking, not within the terms of the provision, is something we have to warn ourselves against, because that will put in jeopardy the whole structure of liberty around which laws are actually based, to protect which laws are in place, and for purpose of which courts have been entrusted the responsibility of interpretation.
Right. Thank you. Thank you so much, sir. So I'll just I'll just dump through a few of the things that were held in the judgment and take you straight to the reverse onus clause that is under section 24 of the Act. So section 24 talks about burden of proof, and it says, in any proceeding relating to proceeds of crimes under this Act, in the case of a person charged with the offence of money laundering under Section 3, the authority or the court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. And B, in the case of any other person, that would be any other person who's not being charged of an offence, the authority or the court may presume that such proceeds of crime are involved in money laundering. So this is now, it seems to attack the presumption of innocence, which is one of the foundational tenets of criminal law. Now, the idea behind presumption of innocence is also this long-standing idea to balance the unequal power distribution where an individual is facing trial against the might of the state. However, many statutes have a reverse onus, reverse burden clause. So, sir, could you speak a little on the reverse onus clause under the PMLA? And in your opinion, is this a proportionate interference with Article 21? And just also on how the court has interacted with this question.
Well, reverse burden is not unknown to law. And even Wilmington has noticed statutory exceptions, of course, from other categories. However, merely because you can detract from it doesn't necessarily mean that you can easily move away from it, because, as you very correctly mentioned, presumption of innocence is a fundamental tenet. When the movement away from this fundamental tenet should take place depends upon several factors. And unfortunately, while to some extent I am in agreement with what has been spoken, I have my reservation about the way in which it's expressed, because the judgment doesn't spell out, in my opinion, clearly what is very relevant for the purposes of reverse burden of proof. Why I say so, there's always a difference between evidential burden and legal burden. And I personally feel that the court, though of course you can read between the lines to say that the burden has been understood as the evidential burden, not the legal burden. The court should have been absolutely explicit in setting this out, which it hasn't. And the purpose of the apex court, the Supreme Court, dealing with matters of substance like this necessarily warrants clarity and exposition, because then this is a law for all time to come, and it is binding, and clarity of law is one of the basic attributes of rule of law. The ambiguity detracts from the worth of a judgment. But that said, what I want to say is that as far as reverse burden is concerned, the requirement should be one, what is the offence, nature of the offence, where reverse burden is sought to be imposed. Two, whether the accused on whom the burden is placed is in a position to discharge that burden. Three, is that the burden of the offence as such or an element of an offence? Because this is also very, very relevant. And four, in totality, what you correctly mentioned, is it a proportionate imposition by law with the legal process as to render the method reasonable within the meaning of what Menka Gandhi interpreted 21 as. Ideally, all these factors should have been part of this particular judgment. And then the interpretation of 24 should have been around these factors, which had given it conceptual clarity. But I don't find that, as I said, insofar as the legal and the evidential burden and the aspects are concerned, I don't find that present in this judgment. What makes things worse is the third aspect, the meaning which has been placed on the word charge in 24. Now, charge is used many times in statutes not as order framing charge. Charge is used as an accusation. And 24 means, when it uses the word charge, doesn't mean charged meaning of an order on charge by a court, but means one who's accused. Now, the reasoning, strangely, after correctly saying, I would say that correctly, that yes, reverse burden is permissible and this should be evidential burden, which is reasonable. After correctly saying, it then goes on to this aspect of charge. Now, this charge is a troublesome thing. It's very useful for those accused of money laundering. I'll come to that in a minute, but I'm talking about how it is conceptually wrong. Because the word uses charge, they justify reverse burden on the basis of 106 of the Evidence Act, saying that the material would be with the accused to rebut the assumption, because the prosecution discharged the onus by placing enough material for a court to frame charge. This is a completely wrong interpretation of 24 for two reasons. One, charge is not used in the sense of order framing charge. For that reason, using 106 in the sense it is used is also consequentially incorrect. Third, and this will actually work to the benefit of those who are accused, if this is the meaning of 24, then for proceedings under Section 5 and Section 8, 24 may not be available to the prosecution for invocation because charge may not, even a complaint may not have been filed. So there's no question of framing of charge. So is the court saying that for 5 and 8, 24 is not applicable to the prosecution? That will be a natural sequitur for that to happen, which is left completely unaddressed in this particular case. And fourth, if you have a question on 45 and 50, I'll deal with that later. This will have a bearing also on how 45 and 50 will play. Now, this is one of the issues which I find lacking in the judgment, because a statute is always construed as a whole. A statute will never have isolated silos. That's why your principle of ex seribus actus. So when you interpret the statute and you deal with the virus, while dealing with individual provisions, it is obligatory to see the consequence of that interpretation or other provisions and then present a picture dealing with the act as a whole. What I find lacking in this judgment is this linkage or interlinkage, because whether PMLA is intra-virus or not, what has to be seen is how it has to be construed in totality, which is again absent over here. So just to summarize, one, it's not in every case that reversal of burden is unconstitutional. To decide upon unconstitutionality, the 4 or 5 factors I pointed out have to be relevant. 24 had to be tested in that context. 24 is not so tested in that context. 24 is not dealing with the distinction between legal and evidential burden directly. And to the extent the court reads 24 to mean charge, the court, in my opinion, misdirects itself.
Right. On this point that you had mentioned about the interaction of various provisions of the Act, I'll just take you now to this most contested provision, which is the twin conditions of bail. Now, sir, in the judgment of Nikesh Tarachand, a small aspect of the twin conditions was under challenge, which is the reference to predicate offence, which was in the previous version of the section, and then an amendment was introduced, and the section in its current form was formulated. So, sir, what would you say is the effect of the judgment of Nikesh Tarachand on how the bail conditions have been construed?
Well, I feel Nikesh Tarachand was irrelevant to determination, whatever way Nikesh Tarachand would have been. And reliance on Nikesh Tarachand was too simplistic an argument to have been taken, which gave an opportunity to the court to deal with this particular issue rather differently from what it should have. Now, see, what is missed is, and again, it's very unfortunate, it's not been so presented. What is missed is, this is pretrial detention. Now, pretrial detention goes to procedural due process. Now, when it goes to procedural due process, 21 comes in. When 21 comes in, you have to see what are the ingredients of this procedural due process. Now, the ingredients of procedural due process become very relevant because 45 is premised upon guilt. Now, how do you disprove it? Now, for the purpose of disproving it, there are various factors. What normally would happen is, A, is there an opportunity with the person to lead evidence for the purposes of showing that, see, this is unwarranted. Now, normally what happens is, even at the state of charge, you cannot bring in any evidence. You say, okay, you are going to come at the time of trial, bring evidence over there, right? 45 doesn't have that particular provision that you can actually bring evidence for this particular purpose. Number two, what are the statutorily enumerated factors which a court has to take into account on the basis of the material which is over there for it to conclude that the test is satisfied as far as 45 is concerned, because that goes to the subjective opinion of the court. But a subjective opinion of the court which is unchecked by any standards to review it.
Right.
Now, when it is unchecked by a standard to review it, it goes to the complete discretion of the court to decide one way or the other. Now, the discretion of the court to decide one way or the other may be an impression which is the court, but you cannot conclude matters on the basis of impressions or mere subjective opinion, because the check on that opinion is the restraint of law and the standard which is absent altogether. Now, there is no standard to control discretion, and there is no option to prove innocence. On what basis 45 work? Whatever Nikesh Tarachand may say. What Nikesh Tarachand said, now the whole object was, see, there's another judgment. This approach is wrong. We have in this today, we go too much by judgments. Okay, let's find a judgment, cite the judgment. We are not to go by judgments. We have to go by concepts. We have to go by principles. And when you deal with a provision, you have to go to the principles on which the provision is based. Because if the principles are violated, no judgment will bind you. And the Supreme Court is not bound by itself. So you can show to the Supreme Court that the principle is absent. Now, where 45 is concerned, the test for the purpose of applicability of 45 is absent. But more importantly, I have read in this particular judgment an argument of Validation Act. Now, Validation Act is used by the court to justify this. But this is not a validating act. This is a money bill. This is in the case of that which issue has been kept in any case at large by the court. Now, Validation Act has its own discipline. It should be brought about with the purpose of addressing what is actually a wrong. But in my opinion, to call it a validating act is again not correct, because I don't see, because the court has kept that issue. Now we should keep the way of introducing the amendment at large and say we are not getting into it. And without getting into it, yet call it a validating act. You are validating something, the subject of which is still to be decided by a 7-judge bench for the court. So with that issue at large, to justify it on this basis is again, in my opinion, not correct.
Right. So, sir, just on this point that you were mentioning, so in section 45, we see that the court needs to be satisfied that there are reasonable grounds to believe that the person is not guilty of such offence. Now, you pointed out that this might be more onerous, and it gets to the subjectivity of
and
the judge.
Procedural due process.
Right, sir. So, at this stage, also material evidence would be absent, is it not?
You see, that is this is a problem. See, that's the reason why. Again, I mean, I'm without sounding too critical, I bring in the question of interconnection. This is where 19 becomes very relevant. You see, now 45 had to be read in the context of 19. Now, 19, in my opinion, is the most important provision in Pmla. Because you look at 19 is a complete departure from section 40 on the CRPC. And makes arrest an exception, not the norm. Because it's easy to arrest under 41 on a suspicion of a cognizable offence. Here, it's not. You have to be satisfied with the guilt. That means you cannot arrest unless you are sure of the guilt. Now, for that particular purpose, now if you can't arrest, there is no question of bail. When will 45 come? The 45 would be justified when 19 has been subject to a preliminary review. And then it has said that, see, 19 was subject to preliminary reviews. The magistrate looked into, or the judge looked into it at the time of remand, or the court have looked into it at the time of 226. Therefore, there is some basis for dealing at the time of 45, the linkage. So you have to link 45 with 19 and then justify that, see, because of 19, 45 is justified. But it was not argued, it was not argued by anyone and definitely not examined by the court. This link between 19 and 45. The problem with acts like Pmla is the reluctance of the courts of the first instance and the courts of review to examine the material for its legal worth for the purposes of concluding whether the provisions are in fact attractive at all or not. If 19 is correctly applied, 45 would be unnecessary. Because in most cases, arrest would be addressed.
Right, sir. So, but the high arrest numbers then are slightly problematic. The high arrest numbers that we see under the PMLA.
Because, you see, the protection of our rights lie with the courts.
Right.
No matter how perfectly drafted a statute may be, it can always be misinterpreted. Who will check the misinterpretation or misapplication? It's a court. And I feel that the Supreme Court should have actually used 19. It had the Supreme Court said that we are upholding, we feel that 19 is a check, arrest should not be routine, difference between 41 is explicit. And for that reason, we feel with little cause for interference and a few of the issues can be addressed. Much of the problem with PMLA would be addressed. Because all penal statutes, unfortunately in this country, the worth of the penal statute as a tool is in the capacity to effect easy arrest. And if easy arrest is addressed, everything else would be automatically dealt with. Which is why the link between 45 and 19 was crucial and critical and should actually have been explored and dealt with further by the court.
Thank you. Thank you so much, sir. So I'd like to draw your attention to Section 50 of the PMLA Act. Now, Section 50, the challenge to Section 50 of the PMLA was based on the fact that officers who are conducting investigations under the PMLA are police officers. So that was the starting premise. And therefore, the statements made to such officers would be covered by Section 25 of the Indian Evidence Act. And also, there would be an implication on Article 20, Clause 3. So, the petitioners have heavily relied on the judgment of Tofan Singh, where a similar question pertaining to NDPS officers was being considered, and which I must point out to our listeners, Sir had argued and argued very well.
I'd argued and lost for reasons it should be subject matter of separate podcast, but let's leave that. Yeah.
Right. Now, the court says, deals with this question by saying that the scheme of the NDPS Act was completely different and therefore it should not be a part of the PMLA scheme. And the PMLA scheme is distinct and the NDPS provisions and the NDPS interpretation would therefore be not a part of this. So, sir, what do you have to say about this and this approach that has been taken?
This at the outset, maybe bias, whatever, but we'll leave. I have my reservation about Tofan Singh. But whatever that may be, not because I'd argue that matter, but that's not. The question is, just like Nikesh, Tarachand and Shah, as far as Tofan Singh is concerned, were not decisive of the matter. This is very, very, very important. And the overemphasis on 25, in my opinion, is also misplaced because apart from 25, no one knows it's 24. So it's not necessary that a person has to be a police officer for there to be protection because there's 24 yet of the Evidence Act, which will in any case cover any kind of imposition on a person as to extract statements, which detract from the voluntary nature of it. But that's that apart. Now, the few things which I feel I have reservations about this judgment. One, to the extent it says that, the inquiry is for the purpose of attachment. And therefore, investigation is not the same as is understood in the CRPC. This does violence to the scheme of the Act because it's quite obvious that there's prosecution in PMLA. There's attachment, yes, right, but there's prosecution. And the material is for the purpose of prosecution too. And if it is for the purposes of prosecution, in that event, you can't simply say that it doesn't have a penal element to it, unlike NDPS, because NDPS is also punitive. So, I mean, there may be this distinction between NDPS and PMLA from this for this reason, in my opinion, not correct. So you can't simply say that NDPS was a penal provision, therefore Tofan Singh. Ideally, the court should have examined Tofan Singh to see whether Tofan Singh is right or not. And that would have made this judgment comprehensive because there are many aspects in Tofan Singh which, in my opinion, are not correct, which required examination by the court, and this is an opportunity for the court to examine it. But the court actually has chosen not to deal with Tofan Singh. That's a very detailed judgment and would require a fair amount of inquiry for the purposes of distinguishing it from PMLA. This is number one. Number two, you see, insofar as this question of 20 is concerned, we have to keep one thing. We have to be emotive about a few things, but we can't let our emotions rule our judgment, because either way, law is a casualty. Now, this I just want to bring in a caveat over here. Now, where right against self-incrimination is concerned, we have to have a nuanced understanding of that. And why I say you have nuanced understanding? Because at play are two competing interests. One is the right of the prosecution to investigate, and the other is the protection of an accused from being compelled to incriminate. Now, 20 will operate over an area which will cover both relevance and incrimination. And to the extent the questions deal with relevance and not incrimination, they are outside 20. Now, whether there is a transgression from movement from relevance into incrimination would be a question of fact in each case. No one can anticipate that in the course of an examination, a question which is being put will incriminate. Both the nature of the question, the kind of the offence, the circumstances which have been asked, will all cumulatively help in deciding whether it's incriminating. Once it is incriminating, 20 will come in. But then whether it is incriminating at all or not will be the job of the court to see at a time when the statement is used, like a disclosure statement. A disclosure statement is taken on record, but the disclosure statement is not admissible per se. And to the extent it's hit by 25, it is excluded. But to the extent linked to 27, it is included. And the court decides how it has to be used. So the same purpose would be even statements under 50. Now, statements under 50, you can't interdict the statement. That, forget Tofan Singh, forget police, forget it, go on principles. Now, when you go at principles, this is something how you will construe it for the purposes of understanding. I don't find that. Ideally, the Supreme Court should have examined 20, looked at the history of 20, looked at the judgment relevant to 20, and looked very importantly to Nandini Satpathy. Because Nandini Satpathy had upheld the right of the police to put questions in a IPC offence where there is 162 in any case is a bar. Right? And so far as that aspect is concerned, a thing which is actually missed in PMLA altogether. But anyway, that's something different. So you cannot possibly say that 50 as it is will infringe 20, because whether it will infringe 20 or not will be a question of determination by the court, and that by itself will not be in any way decisive or that particular matter. Thirdly, this distinction between police and the others, to say that the appropriate authorities are not police, in my opinion, again, is artificial and doesn't in any way accord with an understanding of what it is. Of course, I have my own view about police is, because there are series of judgments. Just for the convenience of our listeners, they can be construed in 3 or 4 different ways. Police can be a policeman properly so-called under the Indian Police Act. A policeman can be one expansively interpreted who's got a power to record a confession. A policeman may be one where the report which he files is under 173. Now, there are various strands across judgments where there are different tests at different points of time which have been applied. In a matter like this, the Supreme Court should have examined all those judgments, whether the Constitution Bench judgment or other judgments, to cull out the principle. That would have been a comprehensive enunciation of who or what a policeman is, which is again absent over here. So there have been opportunities here to clarify the law and explain it in a fair amount of detail to remove the cobwebs in the interpretation, which I feel has been lost.
Right. Thank you so much, sir. So on this aspect of who a police officer is and the test that you were laying down, which also has been laid down by various constitution benches of the Supreme Court, which is that a police would be considered to be somebody who has the power to file a final report. So, sir, do you think this is a very hyper-technical approach, or do you think that what the person is actually doing and what powers he's actually exercising should be the true test?
A difficult question, again. Will not be... there'll always be different opinions of it. The natural inclination of those who are going to be on the wrong side of the law is obviously to say that any person who can extort a confession is a policeman, and not without reason, because that is in some way in their understanding an assured protection against abuse. But what I want to answer that is that while 25 is a complete bar, it's not as if someone who is not a police officer got the statement that be admissible as such, because that can be excluded from consideration also. I feel, till of course a larger bench construes it, the way in which the constitution benches have dealt with this, drawing upon earlier 3-judge benches of the Supreme Court, and the history of Section 25. This is, again, I had tried to argue this in Tofan Singh. Unfortunately, the court has not dealt with this. Justice Banerjee has, of course, dealt to some extent with this. If you look at the history of 25, the word policeman in 25 is basically a person properly so-called. And there are certain judgments of various high courts prior to independence which have dealt with this aspect in detail. Ideally, I would want this issue to be examined by a larger bench, now in the context also of the PMLA judgment, to settle it for all times to come as to who actually constitutes a police officer. Because at different points of time, different tests are come into play. Though I must tell you, in one of the judgments, I'm forgetting the name. It's the Railway Protection Police Force judgment. I'm forgetting the name of the judgment. The Supreme Court, noting the very famous R.K. Garg's submission, he had taken the very objection which you have taken right now. Let's see, I mean, they are doing everything virtually what a policeman does. So this distinction is artificial distinction. The Supreme Court had noticed it and then said that, see, we are bound by a constitution bench. So this is a very, very important question. But as I said, in the law as it stands, not capable of an easy answer. And ideally, I would have wanted this judgment to actually exposit the law clearly, but it hasn't. Perhaps it was not considered necessary for this case. But on a later occasion, this is a very interesting question which does require an answer. And I feel that the law as it stands today, it has to be one police officer properly so-called, because this judgments, whichever have been relied upon the police report aspect, which we were mentioning, are all premised on statutes where the relevant statutory provision had deemed them to be police officers. So the deeming provision, as you know, is a fiction. And when a fiction is created, the consequences follow. And because they're deemed to police officers, in that way, the 173 principle comes in. But yes, it has got its problems. But the law as it stands doesn't provide an easy answer. As I said, it's better that left to a larger bench for consideration.
Thank you so much, sir. Thank you so much for giving us your time. As always, it's been a great pleasure listening to you and learning from you.